In our understanding, effective service is making the other person know that there is a case against him. I cannot believe in the world that the first respondent does not know that there is a case against him. That's why I believe it must be analyzed by the Court of Appeal. Thank you very much.
If you read the order that was given out by Court on Service, the petitioner had not complied with the order. So my argument was that you can really not come to court to seek justice when you have really not complied with the court order or court directives. And I'm very impressed, excellently, that the trial judge evaluated the evidence and my application and pronounced her ruling in the terms. No, I don't want to indulge in that talk. The issue was only one. If a person, whatever you're saying, if you apply to court and say, I want a court order prescribing the mode. Court order says go, get an OC, make sure that OC witnesses. Now you cannot choose to do otherwise. If you choose to do otherwise, then this is the effect, the implication of that. So I don't think there was dodging. He was in Chitaria, not on a holiday. He was a suspect, he was in Chitaria as a suspect. I'm getting it. So the only way to get a suspect is to serve him through an officer in charge, in his presence. You don't go to Chitagia for a holiday. It's their right. But court has not pronounced safe on his qualification. So I cannot indulge in that. So the issue of qualification does not even arise. I'm getting it. So there's nothing about qualifications.
And the accusation that you've been doing his bidding, you were holding off like his lawyer, yet you are the lawyer of the...
I'm a lawyer for the respondents. I'm not holding out, I'm a lawyer.
For the Electoral Commission, not Segirinya?
No, I'm not for Segirinya. I was representing the commission on a point of law. You get it? Did I say I was representing Segirinya and look to record? No. I'm a lawyer for the Electoral Commission. I'm still a lawyer for the Electoral Commission.
The results of the election for members of parliament for Kawempe North constituency were as follows. Segirinya Muhammad polled 41,197 votes, while Serwada Sulaiman Kidandala polled 7,212 votes, making Segirinya Muhammad the duly elected member of parliament for Kawempe North constituency. On March 18, 2021, the petitioner, who is also the respondent in this application, filed election petition number 5 of 2021 against Segirinya Muhammad as first respondent and Electoral Commission as second respondent, in which he challenged the academic qualifications of Segirinya Muhammad and sought an order nullifying the results and declaring him, that is Serwada, as the duly elected member of parliament. The court record of election petition number 5 of 2021 shows that while the second respondent, that's the Electoral Commission, filed an answer to the petition on April 6, 2021, the first respondent, that is Segirinya Muhammad, did not. On March 23, 2021, Serwada filed miscellaneous application number 226 of 2021 for an order of substituted service and for an order to serve Segirinya Muhammad through the officer in charge, Kitalia Prison. My brother Judge Baguma J. ordered service of the petition in the following terms: that the respondent, that is Segirinya, be served with notice of presentation of the petition through the officer in charge of Kitalia Prison, and the officer in charge should witness personal service of the respondent. That was the order. The Registrar of Civil Division posts a copy of the presentation of the petition on the court's notice board. That was the second point. MA number 557 of 2021. In this application, Electoral Commission sought an order under Section 33 of the Judicature Act, Rule 17 of the Parliamentary Election Rules and the Civil Procedure Rules, that election petition number 5 of 2021 be dismissed for non-service of the petition. In support of this application, Electoral Commission relied on affidavit of Mugia Felix, OC Kitalia Government Prison, who denied service on Segirinya and denied witnessing the said service. In response, the respondent, that is Serwada, filed an affidavit in reply in which he opposed the application to dismiss the petition and deponed that the Electoral Commission had no locus standi to bring the application, that the application is misconceived and raises issues of review. The application is supported by an affidavit without authority from the applicant, that is the Electoral Commission, that the application is a vessel for blackmail, an abuse of process, and a corrupt endeavor against the respondent. Furthermore, that Segirinya was served by the process server on March 23, 2021 at the Central Police Station, Kampala, and on April 1st, 2021 at Kitalia Prison by process server Kato Fred. Counsel Alaka and Muyizi for the respondent, Serwada, and Counsel Alaka and Muyizi for the respondent, Serwada, and Counsel Sabiti for the applicant made oral submissions that I have carefully considered. I note that Counsel Alaka argued only their response that Segirinya was served at Kitalia Prison by Kato Fred on April 1st, 2021. I shall therefore take it that Counsel abandoned all other responses contained in the affidavit in reply of Serwada produced above. The issue for determination, therefore, is whether electoral petition number 5 of 2021 was served in accordance with the law and in compliance with the order of my brother judge issued on March 29, 2021. As rightly submitted by Counsel Sabiti, my brother judge Baguma J ordered service through the officer in charge Kitalia Prison, and the said OC was required to witness personal service on the respondent, Segirinya, who was in prison custody at the time. Rule 6, Sub-Rule 3 of the Parliamentary Election Rules stipulates that service of the petitioner shall be personal, while Rule 6.5 permits the court to direct service by substituted service under Order 5 of the Civil Procedure Rules. Counsel Muyizi for Serwada submitted that the modes of service under the CPR do not apply to modes of service under the Parliamentary Elections Act and the rules, citing High Court Civil Suit number 362 of 2013, Jolly Tumuhimbise versus Jolly Otage, in support, where Madrama J, as he then was, made a distinction between good service and effective service, and does not discuss applicability of Order 5 to service of process in election petitions. I failed to see the relevance of the precedent to the issue before me, so I shall not dwell on it. Suffice it to say that the concept of personal service on a respondent is no different from the concept envisaged in Order 5, Rule 10, which is that, I quote, wherever it is practicable, service shall be made as much as possible on the defendant in person, unless he or she has an agent empowered to accept service, in which case service on the agent shall be sufficient. The point I'm driving at is that the order of my brother judge did not depart from the requirement in Rule 17 of the rules for service to be personal. Furthermore, cognizant that the person to be served was a prisoner, the court directed service through the officer in charge of Kitalia Prison, where the person was held and the officer was to witness the service. The evidence in the affidavit of service that would prove service on the officer in charge is his or her written endorsement on the petition that he or she has received the summons. The fact that the officer in charge, Mugia Felix, has denied witnessing service on the petitioner makes it even more imperative that the only proof of service on him would have been his signature. Unfortunately, the evidence of service is the word of the process server against the denial by the officer in charge of any service. In the context of the order of my brother judge, witnessing service meant the officer in charge had to endorse the petition, and if he declines to do so, the process server was to report accordingly in the affidavit of service. Black's Law Dictionary 9th edition refers to such a witness as an attesting witness, one who vouches for the authenticity of another's instrument that the other has signed. In this case, the officer in charge could be attesting that the prisoner in his custody has been served. An examination of the affidavit of service of Kato Fred shows that his focus was on the respondent in the petition, and at no point did he mention an attempt to require the OC to endorse the petition and stamp it with the official stamp as duly served. Service on the officer in charge could have been construed as effective service even if the respondent had declined to accept service. This means that even if the process server did visit the prison, he did not effect service in the manner ordered by the court. The other aspect of this issue of service was whether the order to pin the petition on the notice board of the civil division was sufficient to constitute service. I find that the order to serve the respondent personally and the order to pin the petition on the notice board had to be effected concurrently, and non-implementation of one meant the service was ineffective. In summary, having found that the officer in charge did not endorse the notice of presentation of the petition, there was ineffective service. The Court of Appeal in Election Petition number 62 of 2016, Dionisia Sisi and another versus Martin Serwanga, pronounced that restrictions under Section 60, subsection 2B of the Parliamentary Elections Act on requirements of a petitioner who petitions as a registered voter to attach a list of 500 signatures of registered voters should not be taken lightly. Applying the principle to the instant case, it goes against the strict application of the special procedures under the Act for me to extend time for service of petition. Having found that service was ineffective, I also rely on a recent decision of my brother Judge Bashaija J in MA number 179 of 2021, arising from election petition number 2 of 2021, Wanyoto Lydia Mutende versus Electoral Commission and Nakayenze Galiwango, where the court declined to grant leave to amend the petition for the reason that the court has no residual powers to extend time for filing a petition. In the premises, the petition is rendered redundant for non-service and is struck off the record. For the reason that the petition was a non-starter, each party shall bear their own costs of this application, that is MA 557 of 2021, that is the EC versus Kidandala, MA 596 of 2021, Serwada versus EC, and two others, and election petition number 5 of 2021, Serwada versus Segirinya Muhammad and Electoral Commission.